The government proposes to replace the 1860 IPC with the Bharatiya Nyaya Sanhita, ostensibly to replace the colonial law which has outlived its utility with an Indian version. Imagine, section 302 will no longer be murder and 420 won't be cheating if the new laws come into place. Of course, that will take time. But for starters, the new law will create absolute chaos, add to the delays. Every stakeholder in the system, judges, lawyers, litigants will need a crash course on the new law to cope with it. Is the chaos worth it? Critics say in any case 80% of the law has been borrowed from the colonial era IPC and therefore there was no need for it. The IPC wasn't broken, critics say. The system was. The system was overloaded with cases, 4 crore cases to be precise at any moment of time, another 1 crore in consumer cases and before tribunals. A few procedural changes disallowing too many adjournments and a bigger budget, staff, infrastructure, technology would have solved the problem. All this the governments of the day are not willing to shell out for the judiciary. So what does the code hold out for citizens? Will it eliminate delays? This is what it proposes. Scientific probe in 180 days and trial in 3 years flat. Judgment 30 days after completion of arguments. The entire process from investigation to trial to be video recorded, trial to be conducted through video conferencing, including cross-examination, so that there is quick justice, and all courts to be digitized by 2027. We are talking here of more money, more infrastructure. Police get greater powers under this law. Till now, they could only seek custody of an accused for 15 days. Under this new law, they can get custody from 60 to 90 days. This is hugely detrimental to citizens' liberty. The new law also introduces a new category of offence, mob lynching, which is punishable from 7 years to death penalty. Of course, that is very much required in this day and age. It does away with sedition, but introduces at the same time a new range of offences against the state. Terrorism, separatism, subversive activities, challenging unity, integrity and sovereignty of India. All this have very wide definitions and could be used by any government to quell dissidents or even arrest opposition parties. All this is hugely detrimental to our democracy. It also creates a new range of offences which play to the gallery: chain snatching, mobile phone snatching, which the ordinary person of course wants, but would be very difficult to implement given the kind of pendency we see in Indian courts. So to sum up, the law promises a lot, and that too in a hurry, quickly. That would require a huge investment, a huge budgetary outlay, which successive governments have refused to give to the Indian judiciary. And therefore, in a sense, the new law is more a repetition of the earlier law and does not hold out anything substantively different from what has taken place in India so far. So don't expect the system to change. If the new law comes in, it would be slightly, maybe marginally better, but unless there is huge investment in infrastructure, budget, staff, technology, all this will not be easy. Thanks for watching.